Minister, really welcome this bill and that you've brought it forward so quickly in your tenure, despite all of everything else that was going on, which shows the priority that you're giving it. And thank you also for acknowledging the great work of David Staunton also. What is extraordinary is that we have to legislate for gender equality at all in terms of pay. We should have long since moved past the stage where women have to prove their worth and that they are of equal value in the workplace. But clearly the fact that the EU have found that 16% disparity and that in Ireland we have a 14% disparity, that demonstrates clearly that we have a deeply embedded gender norms with regard to influencing the rate of pay for women in the workplace and their attitudes to women in the workplace. I really value the Commission report and the words of Catherine Day, particularly in her open letter to the Oireachtas from arising out of the Gender Equality Assembly, in which she says gender equality is a matter of human rights, justice and fairness. It must underpin all of our interactions in a society. The state has a special responsibility to treat all of its citizens equally, regardless of their gender identity, in compliance with Article 40.1 of our Constitution, which provides all citizens shall, as human persons, be held equal before the law. And this is a big step in that direction. There is no doubt that a woman is much more likely to experience career disruption. I've always found, as an employment lawyer, I've always found it astonishing, the attitude of employers towards women who might be of a childbearing age, in their discriminatory attitude of that they're going to be likely to need time off for having babies, as though having babies was somehow irrelevant to our society and not really that important, which is a point I generally make to them, and in their unreasonable attitudes. You know, women are more likely to have to carry on a disproportionate responsibility in terms of in the aftermath of a relationship breakdown. You know, that they are more likely to be the ones that are caring for children. They're also more likely to be the applicants in family court pursuing maintenance, trying to enforce agreements between partners in the care of children. And they're more likely to be the lone parents that are the carers. So in all of that, we need to ensure that when they're in the workplace, that their hour there is of equal value to a man, given that they have so many steps along the way that may disrupt that right and that ability. There is no excuse for it, in my view. So I don't accept the citing of the particular citing of the Women's Council in that regard. Older women, women of ethnic minorities and higher earning women are more likely to be victims of the gender pay gap. It's so bad that effectively, as Senator Riley has said, that from around about the 9th of November each year, we have that women aren't being paid from then on. They're working for free. So I want to acknowledge also the work of the Work People campaign, who've worked really well in highlighting that fact. Minister, I really welcome the provisions of this bill, and the transparency and publication really, I think, is the step and is the way forward. You know, that requirement of having a transparency should also be a factor now in any public tendering, that there has to be a declaration regarding gender pay. I believe that in ethical audits carried out by companies, large multinationals tend to carry out ethical audits on their suppliers. I'd like to see a category in that deals with the gender pay, and that becomes a factor of assessment for companies, because I want companies to drive themselves towards a place of quality and showing that they are a company where gender equality in pay is, and to boast about it, and that for that to be a unique selling point for them also, I think, is really important. I think that it sits nicely in the employment equality legislation, of course, and the fact that the discrimination that it's against women leaves the road open for the Circuit Court and the High Court. I think that is absolutely, but I think it's much more likely that it is going to go to the workplace relations, and that's more likely where we're going to see this litigated. And in that, I think I welcome your clarification, because that was one of my questions to ask, was to how the ruling of the Supreme Court was going to be, that now that it had to be in public. So I welcome that change, because I think public hearings are the best deterrent for keeping manners on employers, because the reputational damage of a case is very good in negotiating factor, and one that I use myself with employers or errant employers. while I understand also that redress doesn't include compensation, as it often doesn't within employment law. However, I would ask that there is consideration made for a retrospective, that it goes back to at least the commencement of this bill. But also, and that isn't an unusual precedent in employment law. I mean, in the minimum wage, in that area, I have had cases where I've gone back 15 years and got awards for people that go back 15 years where there's a disparity or a failure to pay. So I think we should be able to include a retrospective, and I think that would be a stronger. So while we can't do compensation, we can bring it back to when the discrepancy arose and a date from which that could be calculated. And then that would hopefully stop the catastrophically arrogant decision of some employers. And also there are, within employment equality, we have the penalisation, victimisation aspect of it, that if someone makes a complaint, that they have that opportunity then to go back into the workplace relations. So in the aftermath, after they've been awarded and brought up, they need that additional protection of being able to take a penalisation claim as well, because afterwards they may get different shifts, they may get different treatment, employers can become awkward, and there is a long-standing precedent with the workplace relations that if you come back in and are successful in a victimisation claim, you almost get double what you would have got on the first time round. And that is a very good deterrent for employers being spiteful in the aftermath as well. And that isn't to say there are fantastic employers out there. Unfortunately, it's a small few that end up in the workplace relations, but there are a few in the workplace relations who are in there all of the time and then clearly factoring it in. So all of this should be a very sobering warning to employers not to persist in discriminatory practice. I wonder, there are other things though that I think that we need to address, and one of them would be, for instance, and it's outside of the remit of this bill, so I'm not quite sure how we would go about it, but if you take something like the legal profession, we have seen an interesting trend over the last number of years whereby the more lucrative, and there aren't that many that are that lucrative, contrary to public opinion, the very lucrative areas of law are dominated by men. The less lucrative areas of law are dominated by women. And so that's an interesting pattern in behaviour. And then also outside of that, we see whole professions like childcare, where women are the dominant carers, the dominant professionals within that, and again, they're in the lower paid. So although they need a third level type qualification now in childcare, and we have had that fantastic professionalisation of it, we still have this low. And I appreciate that we're in the middle of negotiations and would urge that employment regulation order or similar to be hastened. In summary, really, really welcome it. Thank you very much for all the hard work on it, and look forward to supporting this through the House.
Thank you, Senator.